Chapter 13, The Courts. Here are my lecture notes. This chapter is broken down into 5 sections. The first section is Guardians of the Constitution and Individual Rights. Here's the narrative. From humble beginnings, the judicial branch has evolved over the years to a significance that would have been difficult for the Constitution's framers to envision. While they understood and prioritized the value of an independent judiciary in the common law system, they could not have predicted the critical role the courts would play in the interpretation of the Constitution, our understanding of the law, the development of public policy, and the preservation and expansion of individual rights and liberties over time. The court system, topped off by the Supreme Court, but we're talking about local courts here, federal courts, state courts, you name it, all the way up to the Supreme Court. They have a role as a check on the legislative and executive branch in the government. As you can recall in our discussions in this class, the 3 branches of government each have checks on the other. Now, the court system, I'm not sure that the Founding Fathers could have envisioned the court system making so many decisions as it relates to healthcare policy or individual rights or who can be married in this country and that type of thing. And it's really become, I think, an important tool to protect individual liberties in this country. So let's take a little high-level look at some key terms here. Original jurisdiction is the power of the court to hear a case for the first time. Now, original jurisdictions rarely start at the top. They start at the bottom. They start on a state and local level and work their way up the appellate system. If it's a case, for example, across state lines, you're going to have a federal court involved. If it's just something to do with a local speeding ticket, obviously you're going to go to a local traffic court. So there's a lot of different entryways to the court system, but they all start with the original jurisdiction. Appellate jurisdiction is the power of a court to hear a case on appeal from a lower court and possibly change the lower court's decision. So if you're in a local court and the outcome isn't to your liking, you can appeal it to a higher court. Now, generally speaking, most cases don't get appealed, but if you're in a federal court case and it's a significant finding, you may want to appeal to a federal appeals court, which then could be appealed to the Supreme Court. Now, the Supreme Court has the choice of hearing that case or not, and we'll get to that later on in this chapter. The next key term is judicial review. It's the power of the courts to review actions taken by other branches of the government in the states and to rule on whether the actions are constitutional. So the court systems judicially review constitutional amendments, constitutional statements, executive actions, that type of thing. It's the privy of the courts to be able to review those types of things. One of the most key reviews or court cases that we have in our country was the 1803 Supreme Court decision in Marbury versus Madison. So that was again an 1803 Supreme Court case that established the court's power of judicial review. And the first time the Supreme Court ruled an act of Congress to be unconstitutional. There's that big check on the legislative branch. That's where it first came about, was in 1803. So that didn't take long, did it? Lastly, we have common laws. The pattern of law developed by judges through decisions largely based on precedent. So court cases that set a precedent over a long time basically become common law. Now, our second section here, the dual court system. Here's the narrative. The U.S. judicial system features a dual court model with courts at both the federal and state levels. We've alluded to that already. And the U.S. Supreme Court at the top. While cases may sometimes be eligible for both state and federal review, each level has its own distinct jurisdiction. There are trial and appellate courts at both levels, both on the state and the federal, but there are also remarkable differences among states in their own laws, so each individual state's laws, politics, and culture, meaning that no 2 state court systems are exactly alike. The diversity of the courts across the nation can have both a positive and negative effects on citizens, depending on their situation, depending on what's occurred, and depending on where you are. So, while it provides for various opportunities for an issue or an interest to be heard, it may also lead to a case-by-case treatment of individuals, groups, and issues that are not always the same or even-handed across the nation. I've seen this firsthand, actually. In the state of South Carolina, if you record someone without them knowing it, it's okay. As long as one person party to a conversation is present, physically present in the conversation, and you record them in South Carolina, that's not against the law. In California, it could be a felony. So there's an example. Catch me in class one time, and I'll tell you the story behind that. Dual court systems, our first key term here. The division of the courts into two separate systems, one federal, one state, with each of the 50 states having its own courts. Trial court, the level of court in which a case starts and is first tried. An appellate court is a court that reviews cases already decided by a lower or trial court that may change the lower court's decision. So if the outcome is not where you want it to be, if you're in this court situation, you can appeal to an appellate court. Criminal law, now two different types of law here. Criminal law, a law that prohibits actions that could harm or endanger others and establishes punishment for those actions. And remember there, we covered previously on personal liberties, the Miranda rights, which must be read before someone's charged or arrested criminally. Civil law, a non-criminal law defining private rights and remedies, which can have something to do with property rights. So if you harm someone financially, they can pursue you under civil law. Whereas criminal law is you've literally broken a law, like robbed someone or someone's committed murder or stolen, something. Those are criminal cases. All right. Going on to our next section here, the federal court system. Here's the narrative. The structure of today's three-tiered federal court system, largely established by Congress, is quite clear-cut. The system's reliance on precedents ensures a consistent and stable institution that is still capable of slowly evolving over the years, such as by increasingly reflecting the diverse population it serves. Presidents hope their judicial nominees will make rulings consistent with the chief executive's own ideological leanings. So in other words, conservatives tend to appoint conservative judges. And I'm not just talking about the Supreme Court here. I'm talking about federal courts too, appellate courts as well. And liberals tend to appoint more liberal judge. So the executives expect appointees basically of their own ideological leanings, but the lifetime tenure of a federal court member gives them the flexibility to act in ways that may or may not reflect what the nominating president intended. Perfect alignment between nominating president and justice is not expected. A judge might be liberal on most issues, but conservative on others, or vice versa. You just don't know what they're going to get and then what their opinion is going to be. It's a lot of different things that come the way of the Supreme Court. However, presidents have sometimes been surprised by the decisions made by their nominees, such as President Eisenhower with Justice Earl Warren, who kind of went a call against him on a few things, and President Reagan by Justice Anthony Kennedy, who turned out to be a little more liberal than the conservative Reagan had anticipated. Modern day example, the Chief Justice John Roberts has been largely apolitical and sometimes have voted liberal or conservative, and he was appointed by George W. Bush, largely on his conservative record. So they're not really tied into anything. It's a case-by-case narrative there. So here are some key terms. Precedent. The principles or guidelines established by the courts in earlier cases that frame the ongoing operation of the courts, steering the direction of the entire system. So here's what happens. When a court case comes to a federal court, or comes to really any court, the lawyers involved, the prosecutor, the defense, the judge, they're going to check the precedent before they make a decision or before they pitch their case. If you can establish that precedent is in your favor, as a lawyer, or a precedent that can guide the judge, you have a higher likelihood of that becoming the outcome, because if there's a precedent to rule one way, it tends to overrule in the system. So now there are three tiers of federal courts. First is a district court. These are trial courts in the federal court system where cases are tried and evidence is presented and the witness testimony is heard. Then there's courts of appeals. This is the appellate courts of the federal court system that review decisions of lower district courts, also called circuit courts. So you'll hear circuit or appellate used interchangeably. So, circuit and district courts is used interchangeably. Pardon my error there. Circuit courts, again, the appeals or appellate courts of the federal court system that review decisions on the lower district courts. They're also called the Court of Appeals. So those circuit courts is where the district courts get appealed to if the parties involved don't like the outcome of the initial trial. All right, so enter the Latin. I actually put the pronunciation here for you and me. Stare decisis means stand by things decided. That ties back to precedents. It's the principle by which courts rely on past decisions and their precedents when making decisions in new cases. So enjoy the Latin lesson. Stare decisis. Now, on the selection of judges for a federal court system, there's something called senatorial courtesy. It's an unwritten custom by which a president consults the senators in a state before nominating a candidate for a federal vacancy there, particularly for the court position. So this is not Supreme Court. Supreme Court, while there is likes to be a consensus, you have to get them confirmed through the Senate. This is more or less for state-focused federal courts. So, like the state of South Carolina has federal courts in it, and they would consult with people in South Carolina about a potential appointee there. Now, ultimately, it's the executive's decision, but they do have to get approved through Congress. So there's senatorial courtesy there that you check. So if we're going to appoint a judge, a federal judge in Charleston, we would consult with Tim Scott, who's senator from that area. You probably also would consult with Lindsey Graham as well. Moving on to Section 4, the Supreme Court. This is what everybody thinks about when they think about the courts. Here's the narrative. A unique institution in the U.S. Supreme Court today is an interesting mix of tradition and the modern. On the one hand, it still holds that many of the formal tradition, processes, and procedures it has followed for many decades. It's kind of stuck with that. Its public proceedings remain largely ceremonial and are never filmed or photographed. At the same time, the court is taking on new cases involving more contemporary matters before a 9-justice panel. Again, there's 9 justices. At least there are at this point. That is more diverse today than ever before. When considering whether to take on a case and then later when ruling on it, the justices rely on a number of internal and external players who assist them with and influence their work, including but not limited to their law clerks, the U.S. Solicitor General, who we'll talk about here in a second, interest groups, and the mass media. So a lot of current Supreme Court justices actually started as law clerks to previous Supreme Court justices. So keep that in mind. So there's a lot of meeting of the minds here, a lot of influence, special interest groups, and that type of thing. So what's the structure of the Supreme Court? I'm recording this on November the 9th, 2020, and right now we have 9 justices. There's a political candidate out there that looks like they just won the presidency. He's talking about packing the Supreme Court because they don't like it because it's got more conservative judges. Now, to pack a court, you got to be able to get it through the Senate. And the Senate currently is Republican controlled, so I doubt very seriously they're going to let that pass. So campaign promises are one thing, actuality are a whole nother. So what's the structure of the Supreme Court beyond having 9 justices at the moment? Never say never. Chief Justice, the highest ranking justice on the Supreme Court, that's John Roberts at the moment. That's basically kind of the department chair of the Supreme Court, if you will. It's kind of the manager of them. Their decision doesn't mean any more than the other 9 people's decisions, but they kind of are the point person, the spokesman, the person out front. The Associate Justice is a member of the Supreme Court who is not a Chief Justice. So you have 8 Associate Justices and 1 Chief Justice at the moment. So how does the Supreme Court select its cases? Let me move this up just a touch. Well, there's a docket. That's the list of cases pending on the court's calendar. They have a decision to make whether to hear those cases or not. They can refuse to hear a case, and it goes back to the appellate court, and whatever the last appellate court decided is final. There's something called a writ of certiorari. All right? Now, let me go ahead and say, let me jump to the bottom. Even justices vary on how they pronounce a certiorari. I have gone through this pronunciation 100 different times. There are 9 justices, and I swear they pronounce it 9 different ways. So don't be too tough on yourself, and I won't be tough on me. In fact, what this thing is called 99 times out of 100 is a writ of cert. So that's what we're going to go with, a writ of cert. The Latin pronunciation, I believe, is a writ of certiorari. An order, which is an order of the Supreme Court calling up the records of the lower court so that the case may be reviewed. It's sometimes abbreviated cert again. So a writ of cert. So if you have something come up through the appellate system into the Supreme Court decides they want to hear it, they're going to get all the records from the previous courts. That's what a writ of cert is. There's also the Rule of 4, a Supreme Court custom in which a case will be heard when 4 justices decide to do so. So you have 9 justices. If it gets up to 4 that say, hey, we really need to hear this, and the other 5 say, no, we don't. If you get 4, it gets heard. It's on the calendar. Rule of 4. Solicitor General, this is the lawyer who represents the federal government and argues some cases before the Supreme Court. So if the defendant or the person, defendant's kind of the word, but let's say a a group out there, a state, appeals the legislation of the Affordable Care Act, otherwise known as Obamacare. That's a federal government act, so someone has to defend the act itself, and that would be the Solicitor General. So they work for the federal government. They're the lawyer in the Supreme Court for the federal government, and that is a nationally appointed member of the executive branch. The Solicitor General is chosen. So, Supreme Court procedures. There's a brief. It's a written legal argument presented to a court by one of the parties in the case. You have, again, the Latin here, amicus curiae. And a few people pronounce that differently, but 9 times out of 10, it's amicus curiae. Amicus curiae. It's literally meaning friend of the court, a friend of the court, and is used for a brief filed by someone who is interested in but not party to a case. Basically, it's an expert floating out there. So you might have an expert on healthcare law that comes in and discusses a Supreme Court case on the Affordable Care Act, or you might have an expert on immigration if immigration becomes an issue in front of the Supreme Court. Oral arguments. These are words spoken before the Supreme Court, usually by lawyers, explaining the legal reasons behind their positions in the case and why it should prevail. So these are much like the oral arguments you see at lower level courses. Conference. That's a closed meeting of justices to discuss cases on the docket and take an initial vote. Obviously, they have to have some conferences together to decide if there's going to be enough of a rule of 4 to add. They need to be able to discuss the writ of cert. And they need to be able to discuss the different arguments within an open case to make a decision. So, moving to the last section, that actually is a nice little transition. Judicial decision making and implementation. If I could talk, I'm done with English today. Judicial decision making and implementation by the Supreme Court. So, how did they come to a decision? Well, here's the narrative. Like the executive and legislative branches, the judicial system wields power that is not absolute. There are many checks on its power and limits to its rulings. Judicial decisions are also affected by various internal and external factors, including legal, personal, ideological, and political influences. These are human beings. They have bias. To stay relevant, court decisions have to keep up with the changing times. They have to know what's going on. And the justice's decision-making power is subject to the support afforded by other branches of government, and implementation and enforcement. So they have to understand the spirit in which, let's say, a questionable legislation came about. Nevertheless, the courts have evolved into indispensable part of the governmental system. A separate and co-equal branch that interprets the law, makes policy based on those interpretations, guards the Constitution, think liberties there, and protects individual rights, again, liberties. Now, that's a great overview and great narrative. Judicial opinions, how do they come about? Well, majority opinion is the opinion of the court with which more than half of the 9 justices agree. So you can have a 5-4 decision. The 5 justices in the majority are the majority opinion. If you have dissenting opinions, you can have as little as 1. You can have, so if you have all majority opinion, 5-4, the majority is those 5. It could be 8 out of 9. It could be, as long as it's the majority, that's the majority opinion. Dissenting opinion is opinion written by a justice who disagrees with the majority opinion in the court. So a lot of times you'll have, let's say, like a 6-3 vote. Chief Justice might write the majority opinion for, or a justice might write the majority opinion for the 6, and then a dissenting justice will write the dissenting opinion based on the views of the 3. There's also something called a concurring opinion, and that's an opinion written by a justice who agrees with the court's majority opinion but has different reasons for doing so. So they may agree, say if it's 6-3, they may agree with the other 5 justices that something should or shouldn't be done, but they agree for different reasons, so they'll write their own opinion. 9 times out of 10, you're going to see a majority opinion and a dissenting opinion. And that gives the courts on the lower level and the rest of the nation a set of precedents as to how and why the Supreme Court justices rule how they did. Now, what are some influences on the court? Well, there's something called judicial activism. It's a judicial philosophy in which a justice is more likely to overturn decisions or rule actions by other branches unconstitutional, especially in an attempt to broaden individual rights and liberties. So you might just have somebody that's just bent on that, and so they kind of an activist on the court. They can also be influenced by outsiders or their own individual bias. There's also something called judicial restraint, a judicial philosophy in which a justice is more likely to let stand the decisions and actions of other branches of government. It's kind of a respect for the other branches. They understand the context in which something was created, and perhaps they just don't feel like being an activist on that particular thing, so they just let it ride. It's kind of a precedence of legislation there, if you will. This actually brings us to the end of my 5-section review of Chapter 13, the Court's Lecture Notes. Please let me know if you have any questions. Take care.